Hello again. My name is Frederik Harhoff. I'm Professor Emeritus in International Law at the University of Southern Denmark. Last time we spoke a bit about state responsibility, and in this session we will focus on the law of the sea. Now, all the laws that we've been talking about so far normally apply to territory of the state, that is to say the territory on which you can walk. But states also have territorial sea out from their coastline, 12 nautical miles into the sea, and the territorial sea extending to 12 nautical miles is also part of the state territory, where all the laws apply fully, with the only exception that applies from the fact that you can't walk on water yet. But what happens once you exceed the territorial sea? And could I just introduce you to one little thing that I think you should know? 1 nautical mile is 1.852 kilometers. And that figure is reached by the definition of the distance of the equator around the globe, which is defined as 40,000 kilometers. Now, as you know, the globe is split up in degrees, in 360 degrees. So each degree on the equator line is 40,000 kilometers divided by 360. That makes it roughly 111 kilometers. And so on the equator exactly, the distance between two degrees is 111 kilometers. Now, each degree is by definition subdivided into 60 minutes, sorry. And so you have to divide 111 kilometers by 60, and then you reach the number of 1.852 kilometers. I think it's important for you to know this, just so as to make sure that the magic number there is not just something somebody has invented. It has a background and an explanation, and you should know it. In any case, once we exceed the territorial sea, we come out into, in principle, the open sea. And coastal states have an interest in making sure that their laws are respected even beyond the extension of the territorial sea. The territorial sea is 12 nautical miles, approximately 22 kilometers. Once we're out there, the coastal state still has a strong interest in ensuring that not necessarily all of its laws are applicable beyond the territorial sea, but at least some of them, those that have to do with customs and illegal import of drugs and others, human trafficking, for instance, those laws, most coastal states are extremely interested in preserving their jurisdiction over customs issues and over drug issues and so on, even further out. So we have agreed upon that when we exceed the first 12 nautical miles of territorial sea, then we will add another 12 nautical miles. And the additional nautical miles, the 12 nautical miles, are only reserved, they will only have jurisdiction on these issues that I have mentioned, customs, drug trafficking, and so on. Beyond the distance of 24 nautical miles, we are then basically in the open sea, the high seas. But then there is a question about the continental shelf, because what about the resources that are to be found or can be found underneath the subsoil of the oceans, the deep sea, the high seas? There we may find oil and gas, and indeed we have found oil and gas. So who has the right to extract those resources? Is that the coastal state? And we have agreed again in the Law of the Sea Convention that I will come back to in a minute. It looks like this. We have agreed to extend a zone of 200 nautical miles extending from the coastline of the state, 200 nautical miles out, applicable only on the seabed and the subsoil of the seabed. That's what we call the exclusive economic zone. And in that exclusive economic zone, we have the coastal state has right to exploit and to search for and exploit whatever resources may be found underneath. So here are the three zones. You have the coastal, the territorial sea, the adjacent zone, and then the exclusive economic zone, the EEZ as we call it. So these are the rights that are applicable to the coastal state. Now, what about passage? Because a ship that enters into the territorial sea of a coastal state is in principle invading the territory without permission. And why is it important? That is important because if we go back to what happens on land, you see that most countries have put up requirements for any foreigner coming to your country by requirements of visa, for instance, or entry permits, or other sorts of rights. European citizens, members of the European Union, they are entitled to come to Denmark, to Danish territory without further. The same goes for Nordic citizens, Finland, Swedes, and Norway. So the starting point for individuals entering the territory of another state is that they have to ask for permission and be given permission to enter. Then the exceptions are all the exceptions that I have made by way of European Union, for instance, or Nordic citizens and so on. But people who are outside these exemptions, they have to require an entry permit or a visa in order to be able to enter. That is not quite the case when we get to the territorial sea, because here, if a foreign ship comes and passes over the territorial sea, then they are not required to ask for permission to do so. They can do so freely on one condition, that their passage is peaceful. And so foreign ships are allowed to cross over Danish territorial waters if that is done peacefully and without having any impact on the coastal states, coastlines and so on. So can a coastal state, can they prevent the free passage of foreign ships over its territorial sea? Yes, they can. Under certain circumstances, if there is an acute crisis in the area, then they can instruct foreign ships to stay away from the area until the problem has been fixed. There may be leaks of oil or gas or something, or there may be an environmental catastrophe that has taken place. Of course, the coastal state can then say, folks, you have to stay away from this area for a certain period of time until we reopen it. But otherwise, free passage is a right for international ships to cross over the territorial sea of a coastal state. Then we have international straits. That is to say, straits in which there is no room, there's no corridor of passage between the territorial seas of two states. Denmark and Sweden, for instance, in the Sound, there is less than 24 nautical miles between Denmark and Sweden. So any international sea traffic through the Sound will have to cross through either Swedish or Danish territorial sea. That is why we have said that, straits that are so narrow that there is less than 24 nautical miles, they are designed, named or termed international straits. And international straits, you cannot prevent foreign ships from going through in innocent passage. So innocent passage is the right that you have in international straits. This also means that warships, for instance, in the territorial sea and also in international straits, U-boat submarines will have to come to the surface and show their flag, and that goes also for both territorial sea and for international straits. This concludes our very brief introduction to the law of the sea. It's all written down in the Law of the Sea Convention from 1983. It's a UN convention, as you can see on the symbol, and it has now been ratified by most states of the world. Thank you so much, and next time we'll look at the law of armed conflicts. Thank you.